Giving everybody some time to get here. Seems we do have someone that's invited that was corralled by corp counsel. The first minute, and then I'll call us to order.
I'll just go get it.
At the elevator too.
The 980 houses are looking really.
There she is.
Are they?
Yeah.
Good thing
This is supposed to be some, oh, sorry, I'm late, apologize. Just delivering donuts, I'm sorry.
You might want to live in one of them. They're so nice. They're 185,000.
we were waiting for our invitee to get here, so I haven't called the meeting to order yet.
He's here, he's over by Mary Ann.
Now you tell me. That's 35 seconds. Horror.
I'm just waiting for you to sit down and then I'll.
Oh,
All right, we'll call this meeting of the Planning and Zoning Committee to order. First item on the agenda, approval of minutes from December 8th planning meeting, January 5th planning and deliberative, January 26th viewing, and January 30th public hearing.
So move for approval.
second.
Okay, it's moved and seconded. Any additions, deletions, corrections?
I'll be abstaining because I was missing a couple meetings, so.
Okay. Anything else? All those in favor, signify by saying aye.
Aye.
Any opposed? Okay,
I abstain.
and I don't believe we have anybody on Zoom, correct? So
No.
there's nobody here for public comments, so turn it over to you guys, update on zoning, shoreline zoning.
Public comment?
Oh, Jim, did you want to speak? Sorry.
You want to speak on the public?
Sure.
Okay.
My name is Jim Erdman. I am a chair of the town of Oshkosh. Presently, I've been on town board 22 years. I was instrumental in back in 15 more years ago with the rewrite of the NR 115, traveled around the state, wanted to get more local, and they did a super job of addressing those concerns with the impervious surface, different standards for different areas of development and consideration. And I'm not opposed to zoning. I think we need zoning. Zoning is good, but a lot of times it's best done on a more local level. And that one size doesn't fit all. What didn't back when they did NR 115, it doesn't here with the county having general zoning authority in the shorelands. And so in the NR 115 said that the counties had to have a shoreline ordinance. They had so much time to do it. They didn't draft it in that time. It had to reflect the NR 115 and that. If they didn't do it, the state would do it for them. So the county did it, but as part of it, they call it chapter 27. They incorporated, it's only not that big. They incorporated in chapter 23, the general zoning authority. In other words, they took over all the zoning authority in the shoreline areas, 1,000 feet from lakes, 300 feet from the streams. And that we had a problem with that. So we got legislation. I'm active. I've always been active on the Wisconsin Towns Association, presently on their state lobbying committee, the Town Advocacy Council. There's 9 members in the state. I sit at the table, one of them. And we got Act 41, which was an attempt to return the general zone authority in the shorelands back to the towns, in towns that have their own zoning. And that was in 2014, I believe. Governor Walker signed it. Here, the guy right there with a gray sweatshirt, a green striped shirt. Here's one of the pens. This hangs in our town hall. Well, that didn't work down here. It was never enacted, and that disregarded. And then about 5 years later, we had Act 145. That specified that your shoreline ordinance had to only reflect stuff that related to shorelands. Your setback from the high water mark, whatever it be, averaging or 75 feet, the impervious surface, and that was in anything other than that, it not the general zoning authority, that shouldn't be in there. Well, it still is in there here today. That's what there's been some issues in different towns over time, couple right now, one in town of Oshkosh, one in town of Winchester. So we want this returned. In the meantime, people are digging their heels in. No elected officials it's a hot potato. They want to deal with it. It's an issue at election time. Democrat, Republican bullshit or whatever. Bureaucrats, they don't want to, don't like it that there's a problem there or whatever. Nobody wants to take an issue with it. The county exec over here, he's not going to want to deal with it. It's an election time or whatever. So I made a call. We had a meeting, 4 town chairmen that are pretty effective, been around a while, with our state legislator here a couple months ago. And he was going to look into it. Since then, he's had gallstones or whatever. They're still in session. So I made a call last week. He's getting a little better now. Michael Schra, he was talking to Murphy about this, his other cohort to the north. And I also made a call to a guy by the name of Larry Konopacki. Larry Konopacki, what worked for the Veg Council in Madison years ago. He made the opinion after Act 145 that yes, it should just, that's for the purpose of that legislation. It should just, the general zoning authority should not be part of the shoreline ordinance. And so I called him, he got back to me 2 days ago. Just so before we get all lawyers digging their heels in, everybody thinks you get the biggest high paying lawyer, they're gonna win. Well, judges make decisions. And the judge, trust me, probably is not gonna wanna hear this bullshit that he doesn't know anything about, whoever he is. And so anyway, Larry says right now they're busy in Madison with this legislative session. Gonna be done here within a month. He's talked to Mike Colas, the head of the Towns Association. Those guys are gonna be meeting with the head of the Counties Association and try and iron this out. It's not just this county, it's a statewide issue. I don't know if it's all counties, but they're well aware of it. So I want to bring that to the table today before we start setting up court dates for and seeing who we can get retain the best lawyer or whatever. So I guess that's all I got to say. If anybody's got any questions, let me know. Anything I can do to help here, let me know. Thank you.
Yep.
Hey, Sean.
Thank you for presenting, Mr. Erdman. So if I, as a synopsis, like a summary, you're saying that the WCA and the Towns Association, Counties Association.
The Towns Association said they're gonna be getting together with the Counties Association. They work together. I can't speak for the Counties Association. I'm speaking for Larry Konopacki, who is now an lobbyist for the Towns Association.
And the Towns Association's meeting with who exactly?
The Counties Association. I don't know
Is
who.
it
They didn't
WCA?
tell me who. They said
Okay.
they're gonna be meeting with them to get this
To get it-
resolved, you know, with this legislation
Okay,
that your memo reflects all the different statutes in here, doesn't reflect Act 145, Act 145 or Act 41. So they're gonna be talking on this. They're the ones that work together on crafted these 2 legislations, the County Association and the Towns Association.
Mhm.
This office here, the county zoning is the enforcement arm of the state.
Mhm.
And we're not saying we want all out of zoning, and you're not gonna do NR 115. NR 115 is everything having to do with the water issues by the water. You'll still, you know, somebody wants to do something, they're gonna get a permit, they're gonna have to get a permit from here. You guys collect all the fees. It's just that things that are not really have to do with the shorelines, the general zoning, the side setback, the street setback, and the use of the land, whatever they do on there with conditional uses or whatever, that should be all local authority. It's better governing and on a local level. But yet, this other stuff, anybody doing any structures is gonna need permits. You guys get all the permit fees or whatever, but some of this stuff is local, should be local, the general zoning.
So in your experience then, how many years have you been doing local government?
I've been on, I've been on about 22 years.
Okay, and you're-
This lady here was almost 40 years, just retired from
okay.
in our town.
So as far as local authority, you're saying setbacks, this, that, and the other, just, I'd like to write that down if you would repeat that.
Side setbacks, street setbacks, and land use is general zoning, and we want that in the town.
And that's under
Just
the,
like the rest of the town. We towns, I don't know, what is there, 4 towns, 4 towns left in county zoning?
I don't know,
4.
for,
And there-
okay.
and there's 11, I believe, that have their own zoning.
Do you have your
we-
own zoning?
Yes, we do. Towns were able to get out of, previously, there was 8 towns in and 8
Right.
towns out.
Mhm,
And then when we did the rewrite of the county zoning ordinance back around 2000,
mhm.
towns had a chance to get out. 4 of them, I believe,
Sure.
did get out
Okay,
in that. Not against zoning, it's just, I think you have better zoning here on some of the stuff on a local, on a more local level.
and say again, why? If you can explain why briefly, why is it important for local?
Because one size doesn't fit all. We got these old plats, everything's non-conforming and that,
I actually have a really good answer for that, for you. I don't want to step on you, Jim.
okay?
We're the most unique county as far as water frontage in the state. And like, right, we have the most water area in the state.
We got 2 lakes. Our town has 2
Well,
lakes.
then this is
Either
what I'm
more
saying,
and-
between the lakes and rivers and streams and navigable waterways.
And these old plats.
And everything, we have a very unique county. And the more and more that Madison's and has been taking away from local authority, it makes it even harder on a county like ours, because we're such a diverse county, we almost should have our own. I think you guys would almost agree with that. That we have such a diverse county as far as waterways, water frontage and all these properties, we should almost have our own zoning by each, because you have what fits for a lake doesn't fit for a stream, doesn't fit for a navigable waterway, doesn't fit for the
And
Fox
we got a
River,
lot of-
doesn't fit for.
We got a lot of wetlands, yeah, we got a lot of urban area. It
Yeah.
is a very diverse county.
And that's I think what you're getting at when you say local would do much better than the state does.
Well,
Because the state just does it.
even the
broad.
different towns are different neighborhoods are different.
Exactly.
We could address it on a local level.
Yeah,
So one size doesn't fit all.
Exactly. That's what it's always
Okay.
been
All
about.
right, thank you.
and late as of the last 20 years or so, Madison's been slowly taking a lot of that power to Madison. So,
Okay, thank you.
Yeah.
Thank you.
sorry, I didn't mean to step on you, Jim. I just thought I could help you out a little bit with that one, because the way the zoning's been centralized in Madison so much now with so many things, like with CUPs, we can't even do anything with CUPs. So, sorry. So that will end the public comments. I don't see anybody on Zoom now. Did anybody else have any questions or comments before I turn it over to staff? Oh, who's taking this one?
What is it? I don't know, what?
Shoreline zoning update.
Oh, I guess we have our clerk counsel and Jake here to present some information regarding that topic.
Down over there.
Absolutely, just try to sit at the table, that's fine.
Well, good morning. So I,
I'm sorry, could you say one more introduction? I just kind of,
sure, I'm with the Tolis Law Firm out of Milwaukee. We represent counties across the state. We actually do a lot of work with Wisconsin Counties Association as well.
and your name's Jake, right?
Yep.
I know I've heard you present before, but what's your last name?
Curtis with the C. So kind of working with Mary Ann, your corporation counsel, and actually kind of communicating with WCA as well. You know, this definitely is an important issue. And so, I appreciate the chairman's perspective, and frankly, I would agree with him that this is a really complicated issue. Because for me, I appreciate the history, and I would agree, when it comes to land use issues, Winnebago is definitely diverse, pretty unique. I think the reality is you guys are facing a situation where, from a legal perspective, it's difficult. And I don't mean to kind of repeat what the chairman stated, but really you have a 2013 case that provided direction and I guess its perspective, the court's perspective relating to the town's ability to rely on its general zoning within a shoreland, and essentially said, any zoning decision within the shoreland is going to be preempted. Any town decision is going to be preempted.
I'm sorry, what does that mean? Any town? So
So
2013 case, I just have to, Mr. Chairman, please forgive me. I just want to make sure I understand this correctly.
Oh, go ahead.
Okay.
So basically, if there's ever a conflict between the town or county decision, whether it's a shoreland or general zoning,
Uh-huh.
the county decision is going to control. And essentially, preemption means superseding. Trying to think of whatever
Yeah,
word.
I understand what you're
Yeah.
saying. The county supersedes the state. Is that what you're
The
saying?
town,
The
county
county
supersedes.
supersedes the town?
correct. Right.
Okay,
But I'm just starting, right?
Mhm.
So that's 2013.
okay,
Fast forward to, again, I think the chairman did a good job summarizing all this. 2015 Act 41. And this is gonna be somewhat boring, but I'm gonna try to break this down for everybody. 2015 Act 41. Mr. Chairman, you and I should have co-presented, because I'm just gonna follow your outline here. But you look at 2015 Act 41, that added a provision within Chapter 60. Just bear with me for a moment. So Chapter 60, under 60.61, that includes the general zoning authority for towns. So Chapter 60 relates to towns. And so in 2015, the legislature added Act 41, which specifically relates to zoning and shorelands. And I guess I should kind of add an aside. The legislative council, which right, that they don't have, when they issue opinions, they're not binding authority, but they're very helpful. Mary Ann, I think she would agree with that. That if you have case law, that's the most important thing. And then you have attorney general opinions. That's kind of under case law. They're not binding, but they're what we would call persuasive authority. And then under that, you just have opinions from various entities. Obviously, when a state agency renders an opinion, that can be very persuasive.
can I interrupt?
Sure,
Okay, I'm sorry.
that's okay.
The legislative opinion that I remember
Mhm.
on this case, you're saying is very helpful, and you're referring to the one particular one that we are aware of.
There's two, but
I'm aware of just the one.
yeah,
I'm thinking of the one
there's
that
one.
was provided by Supervisor Miller.
I don't know who provided it, but summer of 2023.
There were two.
There were two. I'm sorry. Okay.
Yeah.
Go ahead.
Those are helpful, right? They're not binding. And I think that's an important point, because as I go through the timeline here, it's important to keep in mind that it's an opinion. And if you read the opinion, I think it's pretty objective.
Mhm.
But we can't really make a decision based on that opinion, is my point.
Mhm.
Even an attorney general opinion,
Mhm.
you're not going to necessarily completely rely on like you would case law. So hopefully that was a helpful aside.
Yeah.
So back to the timeline, 2015 Act 41 adds a provision within Chapter 60 that, again, I think myself, Mary Ann, Ledge Council, believe tried to add some clarity. And I'll just read it. But so it added, a town may enact a zoning ordinance under the section that applies in shorelands, except as provided in paragraph C. A town zoning ordinance enacted under this section may not impose restrictions or requirements in shorelines with respect to matters regulated by a county shoreline zoning ordinance. So,
Do you have copies for us, or could I see that in print? It's,
sure, I mean,
or,
I think, so I think the plan.
or
I
just
guess-
explain it, yeah, because
Yeah, we can,
I'm not a lawyer.
we'll figure out what the work product is. So I have a memo that's being drafted. But I'm working with Mary Ann on that
Okay.
because we're not really sure how we're gonna release this. We can absolutely probably put out like an executive summary,
Yeah, I'd like to see it in print.
which will have all these cases, all the references and citations. But so so we're back in 2015. When you look at that language, I think Legislative Council has concluded that it shouldn't be read too broadly. Now, I think this is where kind of reasonable minds can disagree as to whether or not when they enacted Act 41, were they actually referencing, or did they have in their minds, as the legislature as a whole, were they really thinking of the general zoning, or was this limited to shoreline? Because I think I think all the parties would agree that if it's a conflict between town shoreline and county shoreline is going to control. I mean, I think basically the town has stated that in its letter. So I think we're all in agreement. So the question really becomes like what did the legislature mean in 2015? So the Attorney General in, I believe, 2019 issued an opinion that trying to be diplomatic here, kind of avoided really any reference to Act 41,
Who did?
the Attorney General. So that's a January 2nd, 2019 opinion.
And Jake, was that Attorney General Schimmel?
That was Attorney General Schimmel.
Avoided.
Well, so the way Attorney General opinions work is somebody has to request one, right? The Attorney General just doesn't jump in whenever he wants to or she wants to. He or she is responding to a request for an opinion. And then you can have formal opinions or informal opinions. So this is a formal opinion, which kind of increases the importance of the opinion. It can be cited in cases. So again, it's not binding, but it is, I would say, very persuasive authority when the Attorney General weighs in response to a formal opinion. The request came from Oneida County's Corporation Council, and it related to basically, so I'll just read this sentence. You have requested an opinion on whether a county can impose a single-family zoning provision from its general zoning ordinance enacted under 5969, which is general zoning, in its shoreline zoning ordinance enacted under 59692, in a town that has not adopted the county's general zoning ordinance. So very similar situation to what we have, right now. And the Attorney General concluded that Oneida County has the authority to zone those areas for single family housing because such zoning is consistent with the express powers granted to counties and does not violate any of the specific restrictions on shoreline zoning in 59692, essentially to the exclusion of towns. That opinion, though, doesn't reference the act from 2015, which I think a lot of people who follow this have observed and commented that there at least should have been an analysis. Maybe it's still possible you arrive at what the Attorney General concluded, but you really should have taken into consideration the 2015 act. So fast forward, I'll just one more point, and then we can kind of bring it full circle. Then fast forward to 2019 Wisconsin Act 145. Which actually does come after, right? So the Attorney General opinion is January 2nd, 2019. The Act 145 is the date of enactment is March 3rd, 2020.
March 3rd, 2020.
Correct. So it's a little confusing, but when you have an act, it'll be the kind of the session year. So it's 2019 Wisconsin Act 145. It actually it's published March of 2020.
Okay, yeah.
So it's certainly after the Attorney General opinion. And Act 145 added two key provisions to kind of the applicable statutes. So the first provision that was added was to 59,692. That's the
I'm
shoreline
sorry, just a
zoning.
second. Added two provisions and what, go ahead, I'm sorry.
59,692. And again, we'll make sure that there's a summary of all this because I know there's a lot of statutes being thrown around. So 59,692 relates to shoreline zoning. It adds this requirement. The requirements in this ordinance shall relate to the purposes in 28131. That's essentially the statute that relates, well, it relates to lots of water uses and water quality issues, but 28131 is essentially the navigable waters provision that the state's going to protect navigable waters.
And this is the very first mention of navigable waters? I mean,
What do you mean?
I'm saying the whole, like, being on the committee, I'm hearing about navigable waters a lot because that's part of the requirement. And so is that the very first mention of navigable waters when it relates to shoreline zoning?
No.
No, that's
No.
a stupid question, I know.
No, no. I mean, it's a fair
Um,
question. I mean, in fact, it's a good question in the sense that when you're looking at general versus shoreland, the key question, I mean, if we kind of, we're well down the path here. If you want to start at kind of point number one, the point, your question is good in the sense that if you're talking general versus shoreland, the question is, are you within 1,000 feet of, and there's lots of other different variations here, but the simplest way to think of it, are you within 1,000 feet of a lake or 300
Okay.
of a river or stream? I'm getting that right, guys, right?
Or
Okay.
floodplain.
Or a
whichever's
floodplain.
greater.
Right, so basically any navigable, and it can get really complicated, is something a navigable waterway, but right, let's just keep it simple.
Yeah.
1,000 feet of a lake, 300 feet of a river or stream, it's a navigable water, and so now you're talking shoreland as opposed to general.
And that happened now on 3/3/20. That's what they defined that.
No,
Okay, never
No.
mind. You can just move
Yep.
on, sorry.
the key point in Act 145 is they're essentially, I think it was always there, but I think the legislature was trying to make clear that 28131 applies. So if you look at 28131, it's pretty general language, right? So there was no surprise, but 28131 relates to navigable waters protection. And when you, to aid in the fulfillment of the state's role as trustee of its navigable waters, there can be regulations, I'm paraphrasing here, there can be regulations, and they shall relate to lands under, abutting, or lying close to navigable waters. So that's kind of like the trigger. And then I think this is an important point. The purposes of the regulation shall be to further maintenance of safe and healthful conditions, and there's a whole list, and that includes control building sites and placement and structure of land, placement of structure and land uses. Okay, so the Legislative Council has looked at this, and the way they've argued it is, I think, if you're going to kind of have a question relating to shoreline versus general zoning, look to 28131 to make sure you're hitting those purposes. Okay, so that's kind of point number one from Act 145. And then I'll have one final point, and then I can basically just stop for questions. Oh, sorry, lost my place. The second point is it added a provision under sub 2. And again, we'll figure out how best to get this to the committee. But we're still kind of within that shoreline zoning part of the statute, 59,692. Sub 2, they added a provision. A town may enact a zoning ordinance affecting the same shorelands as an ordinance enacted under this section, but subject to the restrictions in chapter 60. And again, I'm paraphrasing here so people can track this. You then, and this is where it turns into almost a puzzle. So we go back to 60 and we look at those subparts, which relate to shoreline zoning. So it becomes almost circular. And so I think this is where, to kind of bring things full circle, no pun intended, this is where Legislative Council, I think, has struggled. And if you read closely her opinion from the summer of 2023, and ledge counsel will do this, she's not necessarily making a conclusion, but what she's saying is, if a court, this is where I think you have to read the second page of her opinion very closely. She's saying, if a court were to look at this, because we don't have case law, in the sense that, was it Hedgewood, from 2013, has had all these subsequent events, including legislative acts, right? And that's really critical, because, you know, as a lawyer, I love case law. I want to know that that's the binding authority. That's courts are telling us what the law is. But if you have subsequent acts, you know, legislatures can essentially try to fix something if a court has found, you know, so general versus zoning, if the court were to conclude definitively, which I think people thought they did in 2013, that towns have no zoning authority within a shoreland, then the legislature would have just let it be, but they didn't, right? There was 2 additional acts. And so that's ultimately kind of what ledge counsel was saying, is we're kind of in this very weird world where we still have case law, right? Hedgewood is still cited within the statute. So when you look at a statute, there's called statutes annotations, and it's really helpful. It's a list of cases that have interpreted the statute. It's still listed in the statutes, in the annotations to the statutes. So in other words, it would probably still be considered good law, but there's definitely questions, because the legislature now twice over the last 11 years has decided we need to act and address this. And so, and I'll end now, because I think that's kind of where ledge counsel stopped their analysis. So, you know, from a county's perspective, I don't think you can definitively say that that the acts tried to withdraw authority from the counties. I think that's probably too aggressive of a read of those acts. But there are questions, because again, if the legislature thought Hedgewood was correct back in 2013, they would have just left it as is, but they didn't. And then again, to even further complicate things, they throw in an AG opinion, which certainly has more persuasive value than a ledge counsel opinion, kind of saying the opposite, and we're left with a lot of questions. So I'm assuming that's clear as mud, but
Well, it makes it a lot easier to understand why we're where we are.
You did an excellent job.
Yeah.
I mean, I wish I had that whole,
I love binders. Gotta have
Yeah.
a binder.
because
Can I have
you
it?
explained it from day one to present, so I'm good with what I'm hearing as explanations. And whose
I don't know. when
whose
to-
opinions are, how they're, I know case law is very important, but Attorney General would have more pull than a legislative council. I appreciate that.
Yeah.
But your last statement about legislative council felt by doing those acts that they needed to put those acts together. So you're saying full circle. I think that's where we are. Thank you for all of
I
that.
wish we'd have had this meeting last week instead of this week, because I saw Brad Schimmel last Saturday. And I could have asked him about it.
I'm guessing Brad didn't. Well, I actually, so actually funny you
He's
say that.
usually pretty good about getting information like that when I see him.
You can actually see when you look at an AG opinion, obviously the AG is the last signature, but they're, they're not the actual author, but you can see which assistant attorney general actually authored the opinion.
Question.
Actually, I don't know who that one is, but yeah, no, I mean, the attorney general opinions are very important. I think sometimes people forget to look at them. You know, they start with the statute, they go to case law, and they kind of forget about the AG opinions. Because frankly, those are going to be answering really, you know, so if you think about litigation, you have 2 kind of conflicting parties, and you know, it's you know, usually a difficult situation, right? It's a adversarial. That was the word I was looking for. Adversarial situation. Attorney general opinions are nice because, again, it's typically, at least on county issues, it's your corporation counsel. They say, hey, you know, we're trying to navigate this issue. We have a lot of questions. Would you help us? And so it's literally just, you know, the corp counsel writes a letter and sends it to DOJ, and then the attorney general decides if they want to answer it. And then if they do in a formal manner, there's actually a citation, I mean, you can actually cite to them in case law. But that's what makes this difficult. And to be clear, I think it's a well-reasoned decision when you just factor in other case law and the statutes. The problem is, for whatever reason, there wasn't a lot of attention given to the 2015 Act. Remember, that's the one that added the provision within the towns chapter, that 3G, 3R.
That's why I said I wish I would have run into him, because I could have at least asked about that, and he'd have maybe had a, the answer in a week.
Yeah, and so, and I guess as far as options, right, I think, now that I'm involved, and Mary Ann are working closely on this, and I know Mr. Konopacki is a very good attorney. And like I said, I mean, WCA is one of our major clients. Maybe there's something that can be done where we meet with the town's attorney and try to, navigate this. Because, I know there's been, should we go get an attorney general opinion? So I've glowingly talked about attorney general's opinion. The problem is they can sometimes take a long time. And the attorney general is not mandated to give an opinion. They can say no, right? Or they can give an opinion that's very narrow. So like even in this opinion, right, it was pretty narrow. They can say, okay, you're asking us A, B, and C. We don't think answering A and B is appropriate, but we'll answer C. So they're not always as helpful as maybe the requester wants them to be. So and hopefully we can have some productive conversations with the towns association. And then if we can't, AG opinion is one option. Another option that Mary Ann and I talked about this morning is under chapter 281, the Department of the DNR specifically kind of makes itself available to answer these sorts of questions. I was actually previously chief legal counsel at DNR. So that would be another avenue that we could look at to reach out to DNR and say, hey, look, we have a situation in Winnebago County. We're trying to resolve this. We don't want litigation. So can we get, now you're in a little bit of a gray area, because I mean, a letter from DNR, it certainly is not going to be, it's certainly not binding. I would argue it's probably not even persuasive. It's maybe it's probably at the same level as, I'm not even sure. I'd say maybe it's a step below like alleged counsel analysis. It's helpful. And maybe, in this scenario, maybe that's all we need. But I guess I would throw that out as a second option in addition to an AG opinion. But like I said, both of them could take some time. So I think the more we can kind of work together and try to figure this out, I think the better it'll be for everybody.
Well,
We should also add, just for transparency, based on the opinion that was solicited by Chairman Olson to the Legislative Council, she did throw out at the end, and I quote it, however, a court decision would be needed to answer this question authoritatively. Alternatively, an effective court counsel could consider requesting an opinion from the Attorney General. So yes, I understand.
Can I interject something, Mr. Chairman?
Yeah, I was just gonna say real quick, it's an irony that you mentioned going to the DNR, because they're actually looking for a shoreline zoning expert or the Oshkosh office at this moment.
Okay.
So that's in a vacant, must be a vacant position as of right now.
Well, I think in a situation like this, just since I
Yeah.
have some understanding of how
They
DNR
look
operates,
like-
I think this would be the type of thing that would be sent over to one of their, one of their attorneys that, there's several attorneys in that office, because they actually have a big legal, it's about 28 attorneys. They have several people who are very good and very knowledgeable about, chapter 281, NR 115. I'm guessing, that's kind of the path they would go down.
Shauna, go and then I'll come over to you.
Thank you.
So regarding Mary Ann, mentioning that.
The letter?
Yeah. But I really sense the definitiveness of her opinion, though. I felt that it was a caveat to say, but, kind of that disclaimer, but it was a definitive opinion. Would you agree with that?
I think the report speaks for itself.
Yeah.
And I think she says that quote, I am not aware of a published court decision that specifically addresses this question, and reasonable arguments could be made on both sides of the question based on the statutory language. So I would just say, yeah, I mean,
I did sense it, personally, I felt like there was more definitive town support. And I guess obviously being elected, I'm for towns.
Yeah.
I'm for and I know you are, I'm not saying that. So my question is, how can we proceed in the best way to help our constituents? And maybe Mr. Erdman could, I'm focused on, I understand all case law and all that, and I'm just wondering, how can we keep it at the lowest rung?
Okay.
Control.
Yeah. Well, now you're asking me a policy question. I don't do policy.
I think the committee has to make its
Right,
decision.
this is the
Okay.
policymakers, right? I would note in coordination with the county executive, who under 5917 has the authority and frankly, the obligation to ensure statutes are affected legally within the county.
And why is that? Why would that be difficult? Is there any, I mean, I guess I'd like to get your feedback.
Before I go to you, I
This is
just want to make sure
complicated.
it's okay with, I actually want to clear this with the committee to waive the normal procedure and allow him to speak.
So moved.
Or I'm not asking, does anybody have any issues with me? Because this is an issue we all want answers on.
Yeah.
And in my opinion, allowing extra input is a good thing. And
Yeah.
his status as a town chairman, I think, puts him in
Yeah.
one of those informational
Yeah.
seats.
Yeah.
Does anybody disagree with that or have an issue with that?
Mm-mm.
Okay,
I want to thank all you people for getting this person here. He came up with this here, and I don't disagree with anything in there. I think this whole thing, you want to get in the courts, this is a lawyer's dream. Or whatever. Problem is, there was two acts, Acts 41 and 145, that the intent was to allow local general zoning authority in the shorelines. Problem is, they had all these old statutes. They didn't review those. They just put these two new acts in, and now everything references back to the old statutes. And you go circle round and round here or whatever. And yet the intent of these two things, I think this isn't a local issue here where we're resolving this for the state. I think it needs to come from the top down. That's why I think, we just give it a little time here with, I asked Larry Conopagos, well, what are you looking at? We got somebody here that got turned down on the town approved a variance for a road setback, looked at all the conditions and everything, and the county turned it down. What are we looking at? These people are old. They've lived their own property for generations out there. They're looking at if they can't do this, they're thinking of moving. And that, you're looking at what, 2 years from now? He says, no. If we work with the counties association, it's gonna get done by June. Is whether, I'm clarifying this with the county, the towns association, work with the counties association. If we can just step back and see what comes out of that, I think, and then before we start taking, we got a possible court case in town of Oshkosh, town of Winchester, possibly got one. This is an issue, Mike Cole, as head of the Towns Association, knows this is an issue throughout the whole state. It's just that they've been tied up with other issues that they're not looking at it. For now, that's all I got to say. I'm just trying to help the conversation.
appreciate that too.
So the benefit for us to vote on it, to show our feedback though now would be on record and maybe assist others in
Right, but
legislation.
today it's on the
correct?
agenda for a discussion.
I understand that. I'm not,
So
I
Just- yeah.
understand that, but he's talking about waiting. For us to wait, are you saying for us to wait until,
I'm just saying, if we set up a court case here, whatever, with what we gotta deal with all this, I think there needs to be clarification on the legislation here by, not an opinion from the Attorney General, not one from Ledge Council, but the Towns Association and the Counties Association are the ones that worked on crafting these two acts.
okay,
Get some clarification if it means going into doing another act and getting into these old statutes and cleaning them up a little bit, so this stuff doesn't just go round and round in a circle here when you're referencing old statutes with the new ones.
Tom,
I think he brought up a very good point. You've got to remember, no matter how we vote, the county executive is the one in charge. What's ever on the books or whatever, the county executive has the one to go ahead and carry it out. So whether we vote in favor or we vote against it, but if it's on the books, he will be doing it legally and,
Well, I'd like to know what the county executive stance on this. I haven't heard anything.
well,
I mean, we're not privy to some of these meetings, obviously, and I get that, that's not our role and we need to stay in our wheelhouse, but boy, it would be nice to be at the same table.
well, I wasn't at the table either. I just know what he just said and I know that as a
I mean,
fact.
after this meeting, I'm gonna go brief him on how this went this morning. I mean, so he's certainly tracking the issue, but again, I mean, he's hearing the same kind of questions that we're presenting, and so I'm certainly not gonna speak for him. I just simply meant to note, when you have, staff here who are trying to do the right thing
Right,
and trying to interpret
no
a
question.
statute that's frankly clear as mud, then ultimately, in a scenario like that, if there's, if staff is trying to interpret and apply a statute, if there's a question, if there's, there are some scenarios where, it's kind of a 50-50 call. My only point was, right, under 5917, it's ultimately the county executive, right,
Yeah,
who's
yeah.
the head of administration,
Right,
to say, okay, this is the direction, this is the interpretation we're adopting. Obviously, if it's clear cut, you follow the legal path. I mean, obviously. But when you have a situation like this where there's, I think, the legislative council is literally saying reasonable minds can disagree. This is where it's not really a policy decision, it's an administration decision to say, okay, this is the path that we're going. This is the interpretation we're taking, unless and until a court tells us we're wrong. And I think that's definitely the universe we're operating in right now, when you have two ledge council opinions saying there are strong arguments on both sides. Ultimately, it kind of becomes an administration decision to decide,
Mhm.
which interpretation is correct. So, and I think it's fair to say we are definitely in that universe. And I would also note, obviously, John, in consultation with Mary Ann and myself, I mean, Corp Council plays a critical role in this. And, we've talked last night, we met this morning, Mary Ann's certainly on top of it. But again, we have, I think, reasonable people disagreeing on the proper interpretation.
I also want to add on to this. Right now, we're in the unfortunate situation. We all may not be back here by the time that anything goes to court. I mean, we're looking at one more meeting, and then we have the election. So I don't know if it's incumbent upon, and I'm the last person to want to kick things down the road, but I don't think it's incumbent upon us to rush into an opinion on this when we know that there are things going on in the background. And I think this is something that the next Planning and Zoning Committee is going to have to deal with. I know we're gathering information. They're going to benefit because we're asking the questions.
I would, Mr. Chairman, I would politely disagree because I will not be running again and I've been carrying.
Well, I have an opponent. I might not get elected again. So
I'm just
I'm
saying.
not trying to duck an issue here.
This is a very important issue and I really would like to see some type of an opinion from us through my vote. I would like my vote to be heard on this issue before I move on. It's
Oh,
Just saying.
I respect that.
Okay,
Marianne?
question for, well, not question for you, but just, I heard you say Wisconsin Counties Association and Towns Association. I think that would be, whatever goes down here, that would still be a good option for both associations to meet at a table. Doesn't have to be with us, but I sense that you feel that would be a good idea too, because this is a full circle and a tad confusing as to what's going on. That never hurts. That can go on in the background. I think that would help appease a situation with, I'll say, 4 towns that are pretty interested in authority for like Jim mentioned, an example, okay? That's an option, right? And that doesn't have to be anything other than talk this over, get this.
Doesn't have to be delayed, does it?
That doesn't have to be.
Oh, no.
That
no.
could happen
I,
anytime.
I think what we're kind of talking about is A, possible, and B, I think is probably the best option. Right, so both associations have really good lawyers, and resources to, and this happens all the time, right? You have an issue where and it's typically is the towns and the counties have some sort of conflict, right? I almost feel like we're, it's like brother and sister, right? I mean,
Mhm.
we like each other, but there's conflict. And so this happens often. Like, this isn't the first time this will have happened. And again, we know Larry Konopacki, he's a very good attorney. I actually had a lot of interaction with him when I was at DNR. So yeah, I mean, this
And maybe throw that in there too with the legislative count. I don't know, but that can be a side caveat over here. Okay,
the towns in the county meeting.
getting together and having a meeting. That,
Okay,
that,
But to
that's-
me, I would want to know as much as I could about how the meeting went, and I'd like
Right,
to,
right, but they can meet.
in order to vote
I think if you
before
bring together
the term
those,
is over.
and then the towns. can
We
come in.
can't force them to meet and come to an opinion
No,
before the
no.
term's
I'm
over.
not saying that.
We don't
That's what
want
it
that.
sounded
I
like.
want them to just
I'm
meet.
not saying that. I'm just saying, okay, never mind.
I just want them to meet
I would too.
because,
Because we're now putting this out there that let's make sure that we get their opinion, and that would be a wise thing to get counsel from all the people that are in this fully, that have a lot of skin in the game, more skin in the game even.
Mhm.
I'm just saying, I would be very interested in knowing that.
so I mean, I can commit that I
I don't. you don't
I
have to
will
but-
commit to doing what I can to make sure that meeting takes place. I'll probably be part of it.
Right,
And then whether it's from us or if Larry wants to give the update, again, my client here is the county.
Mhm.
So I will certainly give them an update, but I can certainly come back and give an update to this committee.
I
So,
feel you should be at that meeting.
we certainly can commit to that.
Right, but that's not,
I agree with Mary Beth. That would
That's
be good for
not-
you to be at the meeting.
that's not a good, bad guy or nothing. That's just
No.
meet, sit down at the table.
Information.
Information, okay? And then what's worrisome to me is we could toss this all aside and say, well, state statute says our county executive had final say, but I don't know what his final say would be. I don't think he does. I mean, he can revert back to that statute and say, this is what I see it as, but we have legal advice from the Counties Association. The Towns Association will have their legal advice. Nobody needs to sue anybody about this.
I think I'm appreciative that the Towns Association and the County Association are getting together and looking at this. And from what I've heard from what's been said here this morning, let's let them get together. Let them hash it out and see what they think. Because it's obvious that the legislature has twice tried to rectify the problem. Okay, and whether they have succeeded in writing the law correctly to do that, let's let them talk it over. And since they were the driving factor in these other two instances of legislation with 41 and 145, let's let them look at it and see if they think the law is clear enough or if there needs to be more legislation.
Yeah. Now, my only response to that is we all know how quickly legislation moves, and so I'm mindful of the fact that
I understand that.
the debate is taking place as we speak.
Yes,
I'm aware that county executive is aware of Mr. Olson's, Chairman Olson's situation. I mean, I know that he's getting full information. Maybe I need to get into lobbying.
Well, that's kind of what I was getting at, like what Howard said, where it would behoove us to have more for whoever this committee is to have that information from those entities getting together before they even go forward. Because then we know what they're agreeing on or disagreeing on,
I
depending
agree
on how
with
that goes.
Right,
That's why I was saying we don't rush it.
right.
And that,
But I did hear that there was no delay. There's no reason for a delay on them simply meeting as much as like other things,
right,
right? Is that,
but that meeting,
it's
yeah,
easier to meet with the counties and the towns, but there doesn't need to be major delays on a meeting.
No.
I mean,
Yeah.
where,
but I wasn't putting the delays on them. I was saying us making any kind of a decision because of the fact that there's outside information that can change. And that, you know, and it would behoove the county to move forward in sync with the towns, if at all, if we can find that path forward, and instead of us saying, well, this is how we think that we need to go forward, let's see what's gonna work.
Mhm.
Yes,
I contacted Matt Olson last night and updated him. I'll be going in, I haven't, this call came back. I requested a call from Larry Contact, it took a couple days, this call came in the day before yesterday. I'll be talking to John Damo here shortly, and updating him.
Good.
What we do here has nothing to do with the towns and the counties or whatever, that's already set up. And they know that, you know, if it means more legislation, that takes time. They're
Mhm.
winding up the session right now, which is the reason they don't have time to deal with this right now. They're hoping, Larry Contact, he's hoping that when Mike Colas and him meet with the counties association, they can resolve this without more legislation. It's a statewide issue, yet its impacts Winnebago County here.
Mhm.
So, if you guys are gonna go on the record of, what you think about this, that's fine with, as far as setting up with the county, towns and the counties associations aren't gonna come down here, be with you guys. There's 72 counties that this impacts
Yeah.
in the state.
Yeah, I
It's-
guess,
It's a gray area where it's, and like I say, they meant well when they crafted this legislation, but now it's a lawyer's dream because the old statutes were there and it all winds together in full circle and you could fight this forever.
yeah.
Needs to be some clarification
Mhm.
here or whatever until they rewrite statute. In the meantime, if it's 50-50, maybe it could be administrative, how different counties handle it differently or something, but I don't know if that's helpful or not. I'm on that state lobbying committee for the 9 people in the state for the
Mhm.
town association. This will be our main item when we meet next time. Hopefully it's not Zoom. I like the in-person meetings in Madison, but whatever. It'll be coming up the next month probably.
I don't think that you're going to, and go ahead, Mr. Erdman. I do not think that going up to Sea County Executive Damo is going to change anybody along with Mr. Olson. I think whatever the laws are, that's the way he'll vote. I don't think he will buck any of the laws. That's his intent, I'm quite sure, and
Does somebody want to update them about?
no, I do
That
not.
the counties and towns are meeting together. That's all I was gonna tell
I
them.
would think county or corporation council,
Okay,
that's.
And I'll stay out of the office.
So
Do you
you're
have a date for the meeting?
Pardon?
Do you have a date for the meeting?
That's good. That's
Oh.
good information.
What
Do
the,
you have a date for the meeting with the town's council and the county's council?
I don't have it right now.
Okay, but it's been set.
We have them every couple months.
Oh, okay, so it's a regular.
Yes,
Okay.
yes. The lobbying, town advocacy council.
I just wanted to say, Mr. Chairman, that I've spent some time with Mr. Chairman Olson, just learning about it. No, he's not my constituent, but I like the details. And I feel like it's important to get counsel from all entities, which we have done, which that has been done. And our record, of course, before the term is up, selfishly, is important because we're sending a message to others, at least standing up for our constituents, if nothing else, and most importantly. So if we could make, if you, as you're working on agendas and all of that, that's one thing. And to hear from our county board chairman, Supervisor Egan, of feedback that he has is really valuable. That's very valuable. because we all make decisions differently. And I just want to say that if that's probably the pattern, then that's something that I would act on eventually. You know what I mean? If he's saying whatever the laws are, he's gonna uphold. But we,
Well,
I would-
let me ask one question of someone else and maybe this will clear this up.
okay,
Carrie, is there anywhere for us to, as far as an opinion, a decision, is there anything we should be doing on this?
Pardon me, not that I'm aware of.
Because right now we're discussing it and I believe we were doing this was informational. We were trying to clarify the mud somewhat and in a lot of ways today has helped with some of that and in other ways it's made it worse. But I don't know going forward what we can do. If there is anything for us to do other, because the law is the law, we have we have to follow the state statute the way it is.
yeah, but when it's
And according,
ambiguous,
and according to what our corp counsel tells us, who is our legal opinion. And the interpretation that we're getting here, which we're hearing can be taken both ways. Yes, it can be.
it's ambiguous.
Now, well, I do want to be clear. I mean,
But we know
we
that,
may, so Mary Ann and I are going to talk to the county executive and like I said, I mean, there's a possibility that the further we look at this, that, and obviously we're going to be talking to staff, that we decide for whatever reason, whether it's, the county executive in coordination with corp counsel, or maybe corp counsel ends up having a stronger view as to one side or the other. I mean, there is a way to get to a definitive answer.
Mhm.
I would say it's fair to say we're not there yet.
We're meaning the law, you as representing the law versus, we're not there yet. You're not there yet. As far as
Well, ultimately,
gathering
I'm just,
information.
right, I'm just, ultimately,
Gathering
it's really
information.
I think it's the county executive. Because, I mean, we're the ones that are gonna be advising him, but ultimately, again, let's put it this way, right? If this is a situation where it's clear, right? Tons of case law pointing in one direction, then our objective advice would be, this is the law. In a
Mhm.
situation like this, we have to present kind of the varying interpretations. And then I think the county executive, in coordination with the corporation council, kind of makes that decision. In other words, right now, I just think there is ambiguity, but I don't want it to be misunderstood that we can't arrive at a conclusion.
Mhm.
I think we could. Right? And again, legislative council, this is a benefit of having their analysis. And, I don't know the attorney personally, but I know of her. She's very good. So and she's basically saying there's two ways to view this, meaning it can't, right, if this was just, a very clear scenario where there's one correct interpretation over another, ledge council will say that. So in a scenario like this, when they say there's arguments on both sides and highlights those arguments.
But I bet she leaned on the towns, though. She leaned on
Sure,
the towns.
that's fair to s-
Absolutely,
Yes, but you cannot read that opinion to say
because she's
that,
not a judge. I get it.
well, and she prefaced the opinion with the language that Mary Ann referenced. And then again, if you read it closely, again, it's a good opinion in the sense that she's applying in her mind kind of the framework for how a court would interpret the question.
Yeah.
Which I think you always have to be careful reading an opinion like that. So for example, I think she basically has three main points. The second point is you can't view statutory language as superfluous, right? You have to read every word in the statute. I mean, that's a very common kind of judicial analysis.
Yeah.
Where, in other words, you could have 100 judges look at a question like that. 50 may decide it's superfluous and 50 may decide it's not.
Right.
And I would agree she ends up leaning, I mean, what she basically says, like, I think the answer is no.
Thank you.
Yes, but that as opposed to an attorney general opinion that is definitively providing an answer, right? It's a question and they're answering yes or no. That should not be the same way one reads alleged counsel opinion.
I'm just gonna say for the record, though, my impression is that her opinion has been watered down or something, and I'm not comfortable with that because I'm looking for freedom and liberty and all of that. Because I've got constituents that I'd answer to. And so that opinion was leaning toward, and that felt a comfort there. And because she said, but I'm not the judge, that's fine. That's good. Good. I know you're not the judge. It's not binding. But I just feel like that.
I mean, I would agree. I mean, she clearly, like, I mean, again,
I'm
it's not
I'm
my
just-
opinion. She, in her opening
I'm
paragraph.
not arguing with you. I'm
Yeah.
just saying, I'm hearing that from people outside the committee in a way, or sensing that intuitively. And I'm just saying that opinion to me was like, aha, there we go. Thank you. And I'm not a lawyer, but I'm just saying that is the intent of the letter to me in my.
Yeah.
So like I say, I'm not arguing. I want my voice heard before the term's up, Mr. Chairman. That's all I'm saying. Because I mean,
Well,
there are people that are really like Holly Stevens. I never knew her from Adam, and she has worked so hard on this situation, for example, you know.
But I can also
There-
say that this situation is not going away no matter what we do.
Well, we can make a difference though.
And again, all of these people are gonna be getting together. You're gonna be meeting with staff, you're gonna be meeting with the county executive. And I have a feeling we'll be hearing from staff if there's a change in direction or how they feel. I know, and I'm not going to shy away from putting this on the agenda. I'm not going to actively look to put it on the agenda. I'm telling you right now, just being honest. If staff comes to me and says we need to put this, or this should be on the agenda, I will not fight that,
Why would you let the staff determine that?
because
Why
they're,
are you not listening to us first and foremost? Why do they?
because
run that?
because I think it's valuable information to find out how the county is going to go forward. And that comes from these meetings with the county executive and with
Okay.
staff. Because if we don't need, if there's nothing, if they're gonna move forward in the direction that you would prefer, then we wouldn't have to do anything.
I'm not-
And that's my point. We don't need to tip at windmills that aren't there.
I'm not implying that I'm
And-
putting the cart before the horse. I'm not, I don't want to make it sound like.
No, and
Oh,
I'm
I'm
not,
just rushing into it. I'm not, but I do kind of wonder, why is it that the staff just determines the agenda with you? I'm confused about that, because there's a lot of things that I've really wanted, and I've never gotten anywhere with it. Because it's heavily staff directed. I'm struggling with some of these things. I really am.
I don't understand.
Well,
You gave me a list
if
of
you,
4
if you're
items
the
and
chairman,
you pulled back 2 of them, if I remember correctly, and the other 2 we discussed.
okay, but you as a chairman, if you're meeting directly with the staff about what you want on your agenda, and they have maybe a final say or a major influence, I'm concerned about that.
No, I'm saying they bring items to me that they know we need to act on. And the items go on the agenda. And if it's something in this, like the Sawyer Creek issue, let's go to the Sawyer Creek issue. We wanted closure on that. We wanted an up or down vote. That's all. That was the whole thing. And that was the whole thing. Staff mentioned that to me when I first came in. They said this has been sitting here since, what was it, 2019, 20, or whatever it was.
I'm sorry.
I
I'm
mean,
just
when
gonna-
you elect a chairman, that's just like Chairman Egan has a say on, and he relies on staff for what
Yep.
goes on our agenda.
Right. Yeah, I'm sorry. I'm
If
just. I
staff
need-
doesn't bring it to us, we don't know about it. We can't read their minds about what's supposed to go on the agenda. Am I right, Tom?
No, you're not.
I'd like
Staff
to
don't-
hear it from
Staff
you.
don't bring it to me. Resolutions can, like, if the airport has something and they bring it in. I
Well, you get it
decide
from
what goes
committees.
on or
You get it
off.
from committees, but
But
yeah.
what
Committees
does he
that-
say though?
Right, so, it can be other ones.
have
I
2
personally,
points.
I personally
I
would
just
like to hear an
missed it. Excuse
update
me. I'll be
on
right back.
if anything is
Well,
An
we can
update
have
on it.
that, we can have that next
I
month.
agree with that. I think that we should hear an update if we can.
I don't have a problem with us hearing an update. I just don't know that there's anything for us to take action on.
I've got 2 points.
Yes,
I want item 3. And this, I was deciding before I heard you. I want update and discussion. I would like that on next month's planning meeting.
absolutely.
Okay, agenda.
Because we know what's going on, because they're meeting after this, and that would, I think that would have
And then
been,
the second thing is, we already have state statutes in place, so we physically today can't do anything with those. We can just, and I believe that County Executive Damo knows where the certain towns stand on this.
Mhm.
And if he chooses for the next month to follow state statute, that's his choice. We can't change that. But in the background, we certainly can let the Towns Association, the Wisconsin Counties Association have a meeting, hash this over, get information back to us. If they can meet within a month, I don't know. But that meeting can still take place even after the fact, because I like that the Counties Association and the towns represent the people.
Right.
Mhm.
They represent the towns, they represent the counties, but I'm also represented in this as a small player. They're working for me too.
Right,
So that they can all sit at a table, and you heard Jake say we've gone full circle. We learned a lot of information today. So that tells me everybody's working on their side of it. And I like that, because I don't want this to go to the courts, because that's silly.
Mhm.
But I do understand who has the final say. I'm not saying I didn't understand that before today. So that still stays in place. Next month, put it on our planning meeting, and I'm hoping we have a lot more information. But again, I do thank you for your information, because it was well worth listening to. So those are my 2 things.
yeah, and I was already gonna have that because of the meeting, and that way we would be
Because
able to get their
we've
opinion. We need-
discussed this today,
yeah.
so we can discuss it again next month.
With more information.
Right.
Especially from the county executive
If you
side
all
of it.
agree that, I think that's a good,
And I would very much like to get the report of this that you referenced.
Yeah.
Because I'd like to look those things up, and so whenever that's available.
Weed in the mud.
So whenever that's available, I would
that'd be
appreciate
real nice, yes.
a copy of it.
I know he's busy, but it'd be nice if the county executive would come. He's come here other times and talk, so if he could come, and if not, Mary Ann, but it'd be nice if the county executive to say what his thoughts are. So
We'll lean on them.
well, you should just have to ask him. You shouldn't have to lean on him, but he should just come.
So
Yeah.
we we'll have a March meeting. Election is April 5th, whatever. But if the committees haven't been chosen, we still meet in April.
Right, right.
Okay, just so you, and I think you're
I'm-
aware of that.
Yeah, thank you very much, because April is,
Because
yeah,
that's what happened
I want to stay in
last
as
time.
long as I can. And just for the record, Mr. Chairman, you have handled my agenda items just fine. I'm not complaining about that in particular.
Okay,
Thank you much.
so staff has that direction for next month, right now. See nothing else on the agenda.
I move to adjourn.
Second,
Any discussion? No? All those in favor?
Aye.
Any opposed? Meeting adjourned.